Now I'm going to talk about the free speech clause in the First Amendment. The First Amendment says Congress shall make no law abridging the freedom of speech, which sounds great. What in the world does it mean? Here's your scenario. Number one, a group of neo-Nazis petitions for a permit to hold a march, full regalia displayed through the middle of an Illinois city with a large Jewish population. Is that protected by the free speech clause? Answer, the Supreme Court says yes, that march may take place. Second illustration, a protest is held by an organization that's opposed to the presence of gays in the military at the funeral of a soldier who's not gay, but who is a soldier. So that makes his funeral service, in their view, a valid location, appropriate location for their protest. At the protest, they display placards saying, among other things, "Thank God for dead soldiers," "You're going to hell," etc. Is this protected, offensive, clearly offensive as it is? And the answer, the Supreme Court tells us, is yes. An artist applies for federal funds from the National Endowment for the Arts to work on a project which on its completion turns out to be a photograph of a crucifix submerged in urine. And members of Congress, upset by this, pass a statute requiring the National Endowment for the Arts in future cases in which they're awarding federal funds for arts project to take into account the decency of the proposed project. That gets challenged as unconstitutional under the First Amendment. The Supreme Court upholds it, but on the grounds that the majority finds that that language is advisory only, and that if, in fact, it turned out that the National Endowment award staff were allocating monies in ways that suppressed particular viewpoints, including anti-Christian viewpoints, if that's what this was, that would probably be a violation of the First Amendment right to free speech. And that would render the application of the statute unconstitutional. Or suppose that someone proposed, as is the case in many countries in Europe, that it be illegal to deny the Holocaust. Could a legislature do that? Could the federal government do that? Almost certainly not. That would be suppression of a viewpoint that, however objectionable to many people, is protected under the free speech clause of the First Amendment. So lots of offensive conduct. Lots of conduct designed to provoke, to irritate, to anger, protected under the First Amendment to the Constitution. Our first question has to be, why? Why in the world would we have created a regime that operated this way? So that's the first thing we're going to talk about. And then I want to talk a little bit about the different sorts of speech that are protected in varying ways under the First Amendment. And then we're going to talk about speech that's not protected under the First Amendment. This is what's called the categorical approach to First Amendment scholarship. And because we don't have a whole lot of time, we won't be talking about some important issues involved in First Amendment analysis, including especially the location issues, where speech can and can't occur and what the different standards are in different places. So why? Why do we have such a substantial protective regime under the First Amendment? Well, I think the first answer traces to our history. It's important to remember that the Constitution, including the Bill of Rights, which includes the First Amendment, was adopted during what we broadly speak of as the Enlightenment era, in which leading political thinkers, scientific thinkers, et cetera, were were largely of the view that the human experience was subject to reasoned analysis, which is to say that there were explanations, natural explanations for natural phenomena, that issues could be resolved if rational people would sit down and talk about them rationally. Deliberation was the principal method of discourse. Scientific research into all sorts of things, social phenomena, economic phenomena, et cetera, natural phenomena, was encouraged and respected. And the speech clause is included in the First Amendment in part to make sure that that notion of how solutions to problems ought to be reached was made an integral part of the American system. The framers, I think, wanted to make sure that future generations would take care to deliberate, would take care to hear all sorts of different perspectives, and believed that the presentation of different views, no matter how outrageous some members of the community might find them, was allowed to proceed. The theory was that if a view was outrageous, if it was illogical, irrational, not susceptible to proof, that the marketplace of ideas, that the community of reasoned discoursers, people talking about these issues in the form of community governments, the federal legislature, state legislatures, et cetera, would reject it eventually on the grounds that it didn't make any sense to do it in a particular way, and that reason would dominate discourse and not emotion or maybe religion or other views that were perceived by many of the framers as being not wholly rational, but based on other things than reason. Not that there was anything wrong with these other approaches, and there's a lot of religion in the framers too, but that wasn't to be the principal driving force, I don't think. And I think that's why speech was prioritized as highly as it was, to allow for this discussion of ideas. The other reason that some scholars think the framers included the First Amendment was that we were a nation in part committed to Lockean notions of individualism, that individuals mattered in the system, that the common people had an important role to play in the self-governance experiment, and that individuals ought to be able to express themselves and their unique viewpoints, both to contribute to the way that society developed and to sort of get feedback on their self-perceptions and how they thought life worked, how faith worked, how social interaction worked. And this is why I think we see decisions supporting the rights of artists, for instance, to express themselves in ways that might be controversial. Maybe it contributes in a large sense to the political discourse, but it certainly contributes to the discourse on individualism and the relationship of people to the world, to society, et cetera. These are values, individualism, political participation, and the importance of the vetting, the sharing, the discussion of ideas that are essential to our experience as a self-governing political entity, certainly were important at the time of the framing, and I think are still important today. I'll tell you, and some of you know this, that we stand apart from much of the rest of the world on some of these issues. I mentioned that Holocaust denial legislation is common in Europe, but not here. It would be unconstitutional here. And there are other illustrations that I'll talk about perhaps as we proceed. Now, the categories of speech. The most protected form of speech under the First Amendment speech clause is political speech. This is speech that's clearly and directly intended to influence political decision-making, to contribute to the making of public policy. The lead case on this is a case about which you may or probably will know something, the New York Times versus Sullivan case, which I think was covered in another lecture by Professor Tepker, involved an advertisement placed in the New York Times. It was political in nature. It was in support of the views of Dr. Martin Luther King. But it included some information that wasn't correct. And the question was whether the New York Times could be sued for defamation. It was directed against public officials, and what the Supreme Court said was that this sort of public commentary on public officials is something that we want to encourage, even if it turns out to be wrong. So we'll allow lawsuits for defamation of public officials, but we're not going to allow you to win on such a lawsuit unless you can show that the party allegedly defaming you was actually malicious. So an actual malice is hard to show. Usually these are just accidental mistakes, in which case there is no liability for defamation. And that's a good illustration of the importance, and that's because of the First Amendment, that higher standard. That's a good illustration, I think, of the importance that the Supreme Court placed on the protection of political speech, even when it's wrong. I might note that this stands in sharp contrast to the old colonial British practice of criminalizing negative speech about public officials, even if it was right. We're sort of about as far away from that as we can get, denying even civil liability, even when it's wrong. The second form of speech I want to talk about is symbolic speech, which is really common. So this is when you don't actually say something, and we'll stick with the political sphere, but you demonstrate a particular viewpoint. And the question is symbolic speech protected under the Constitution? And if so, under the First Amendment Free Speech Clause, and if so, how? The lead modern case is the O'Brien case, which involved the defendants burning a draft card, which was a statement of protest against the draft, against the Vietnam War. And so the question was, is that speech that's protected under the First Amendment? And because it's symbolic, you didn't actually say anything. And what the Supreme Court said in the O'Brien case is symbolic speech is protectable. It is protected speech under the Constitution. Now, that doesn't mean that the government can never do anything if you have statutorily punish an expression of something or some act that amounts to symbolic speech, but a fairly high standard, as in New York Times versus Sullivan, has to be met before the court will find that you haven't violated the Free Exercise Clause. The O'Brien test says that the statute that punishes the act, in this case it was the burning of a draft card, has to be within Congress's power and has to further, and this is probably the most important language, an important or substantial government interest that's unrelated to the suppression of the speech. And then lastly, the legislation has to prohibit no more speech than is necessary, which is to say, if the government criminalized the burning of draft cards and the only reason they could give for criminalizing it was, we don't want people to burn draft cards and so express dissatisfaction with what we're doing in Vietnam, that would be a government regulation designed to suppress speech. And that would be unconstitutional under the First Amendment. So the government has to come up with some other rationale. And they happen to in the O'Brien case. But in many symbolic speech cases, the government is unable to come up with an alternative rationale. And so that symbolic speech will be found to be protected as well. Commercial speech. Now, for a long time, commercial speech wasn't considered protected under the Free Speech Clause of the First Amendment. Commercial speech is advertisements, for the most part. It's publications or communications that propose commercial transactions. And for a long time, the court was of the view that that isn't the sort of speech that the framers intended to protect in the Free Speech Clause, but in the 1970s, they changed their minds. So now commercial speech is protected under the First Amendment, as long as it's true. false commercial speech isn't protected under the First Amendment. And moreover, the government interest in regulating it, or the way that the government actually can regulate commercial speech, has to involve substantial interest. That's the test. The interest of the government in regulating commercial speech has to be substantial, and the regulation has to directly achieve that end, that interest, and the regulation can't be more extensive than necessary. So commercial speech used to be unprotected, but now it's, if true, protected, and that's the level of review. It's not as protected as political speech, but it is protected under the First Amendment, the Free Speech Clause. Now, what speech is unprotected? This group it's an interesting group. Some of it you already know. Obscenity is unprotected. This is probably the most famous type of unprotected speech. It gave rise to the famous definitional problem. Well, what's obscenity? That for a brief period was resolved by a justice as saying, well, I know it when I see it, which may be or may have been true. We still have obscenity prosecutions. The difficulty in all of those, of course, is defining it as obscene. If the material is obscene, then it's outside the protection of the First Amendment. But if it's not obscene, then it comes within the First Amendment protection. Advocacy of illegal conduct. This is when you encourage someone to commit a crime. But it's not any encouragement of criminal activity. The encouragement has to be to commit a crime now. The illegal conduct has to be imminent. You have to intend that the crime will be committed. And it has to be likely that the person you're speaking to or communicating with will actually commit the crime. If you satisfy all three of those, then the speech is unprotected and the government can criminalize it, which is what happens. And lastly, fighting words. Now, fighting words is one of my favorites. This is, fighting word statutes actually first appeared in state legislation in the 19th century. And what they did was to criminalize things that formerly would have given rise to duels. So if you insult me back in the old days, I'm supposed to shoot you. We're trying to get rid of dueling. We think it's not the way things disagreements should be resolved. But we respect that you've been insulted, so we're going to pass a statute making what that person said to you criminal. Fighting words are unprotected. They can be criminalized. If a legislature says it's a crime to say something intended to provoke retaliation, or that's likely perhaps to provoke retaliation of the following sort, then that may be upheld as constitutional. The problem is that virtually all of these are so vague as to be unenforceable. Because who knows how would you list things likely to? You can say something in a certain tone of voice and it'll be provocative. It might have given rise to a duel in the old days. So they're very difficult to capture. But if you have a fighting word statute that's sufficiently carefully drawn, then fighting words are outside the protection of the First Amendment Free Speech Clause. The last thing I want to say a word about is something that I started with, which is offensive speech. So the question is, well what if it's not a fighting word? What if I'm not saying something that's intended to provoke immediate response? What if I'm just obnoxious? What if I, am espousing a view publicly that I know is going to irritate people or make them angry, but maybe not immediately? Maybe, what if I'm advocating a position that's offensive to a lot of people? And this could be on a religious topic or a political topic or a historical topic or whatever. Can offensive speech be prescribed? Is offensive speech entitled to protection under the First Amendment Free Speech Clause? The answer to that is yes, it is protected. And no, it cannot be prescribed if there's no immediate provocation intent or likely consequence. So back to the Westboro Baptist Church and the protest of the soldier's funeral. That case went to the Supreme Court in 2011, and in an opinion by Justice Scalia, the Supreme Court said, you know, offensive as that is to not just the family, but to anyone who hears about it, that speech is protected under the Free Speech Clause of the First Amendment. That's how far we've been willing to go as a society to protect freedom of discourse in a democracy. And I think that fact holds an important lesson for us. Thank you.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.